Good morning, everyone. Welcome to this morning's Knowledge Bank. Today's session is being presented by Darren Coleran, a partner at Bolt Burdon, and he is going to be speaking to you about the Leasehold and Freehold Reform Act. If you have any questions throughout the webinar, please submit them in the Q&A box at the bottom of your screen, and we will try to get through as many as we can at the end. The webinar is being recorded today and will be available to watch back via the News on the Block YouTube channel. That is all from me. I'm now going to hand you over to Darren to begin.
Yes, good morning, and thank you for the introduction, Vicky. Good morning, everybody. My name is Darren Coleran, and I'm a partner here at Bolt Burdon, Solicitors in Islington. I have a mixed practice of landlord and tenant. I represent also a number of managing agents throughout the country. For those of you who may be logging on and know me already, you will know all too well how much I hate public speaking, and it's much more difficult, certainly, looking down as we are now into a solitary camera, wondering, am I alone? In any event, I shall try my best to keep you all entertained for the next hour, and to try and give you a little bit of information concerning the Leasehold and Freehold Reform Act of 2024. Now, when we approached using the blog with a view to hosting today's event, we did so very much not expecting the bill to make law. It is, I think, the single most contentious piece of landlord and tenant legislation, certainly in my career, and there was an expectation, I think, that the House of Lords would get the teeth into this, and that we'd start to see it then pulled apart, and some of the more glaringly obvious issues considered further. Unfortunately, for us all, I think that didn't happen, and the bill has been pushed through. Now, in terms of the inception, if you like, of the bill and when it becomes law, whilst it is law now and forms a part of our legal framework as practitioners, managing agents, lawyers, it will be necessary for the government to issue further regulations and to issue also some statutory instrument to give effect to the substantive parts of the legislation. It should come as no surprise, therefore, that the anticipated start date is between 2025 and 2028, though realistically, post-election, I think we should start to see some of the softer, if there are such things, some of the softer provisions start to drop in, and certainly I think from a practice perspective, we'd all welcome that. Before starting, we've with clients, and since the passing of the bill, we've hosted 3 or 4 of these seminars and continue to host these seminars such as this in real time for clients new and old. And generally speaking, the runtime has been between 2 and 2.5 hours. So what we've tried to do today is to really just extract the really nitty-gritty substantive points that are likely to affect your clients, whether they're the landlords or RMCs, and to give a broad overview of the legislation. By no means a definitive presentation. I hope it does, however, capture the key points that we've all been reading about and seeing on LinkedIn. So the background to this goes back to in and around 2017, when the government and the Law Commission decided that they wanted to have a look at practices and abused processes within the leasehold system. Now, up until 2017, we all knew, of course, that there were landlords out there who perhaps took a more aggressive tone in interpreting the lease, and equally that there were tenants who, perhaps were not always mindful of their obligations when purchasing and then living in that shared environment. However, what really acted as a tipping point was the sale of leasehold houses on a long leasehold basis with escalating ground rents. Typically, these properties were in the northwest, northeast of the country, less affluent areas. And before very long, started to get all of the wrong sort of attention in the press. It wasn't unusual to see references to virtual freehold and my favourite, leasehold. Now, virtual freehold, just to give you a little bit of context was akin to a developer saying to a purchaser at the point of acquisition, guys, here is your brand new house. It is virtually freehold. Actually, it is leasehold. It's on a 999-year lease, but in addition to, it has these nasty escalation provisions dealing with your ground rent. Not every property was affected. However, the number was sufficient enough to, I suppose, kickstart government into looking at this a bit more in depth. So, running alongside, running alongside the work of the Law Commission, we also had a very strong reform movement who have been critical of years about perceived abuses within the leasehold system. Interestingly, when there was a national call to arms, if you like, of leaseholders, from memory, I think just under 17,000 participated, and that the predominance in terms of issues identified surrounded ground rent as opposed to service charge and some of the issues that we're seeing now. And I think that's quite an important point to make. In 2017, and certainly from 2017 to where we are now, the direction of traffic for reform has changed exponentially. We've gone from being, ground rent, a ground rent driven movement, if you like, to now looking at service charge and the regulation of managing agents. So we have travelled a little bit of distance on this journey to reform the law. During that time, there have been some casualties. I think landlords would be the first to admit they've been hard done by. And equally, managing agents in recent weeks and months have received quite a bit of negative press on social media platforms and on LinkedIn. I think it's super important to remember that managing agents, whilst you do manage buildings, you're in no way to blame for escalating insurance and gardening and lift maintenance costs. And that, perversely, the government seems to have ignored the cost of living crisis that we've all been living through. And in part, that has lent itself to this legislation, which does feel as if it's become heavily politicized. And unfortunately, it doesn't lend itself to very balanced law, and certainly law that is going to need constant amendment in much the same way as we've seen with the building safety legislation. In 2022, we saw the first raft, if you like, of reform with the ground rent reform legislation. This essentially prevented, on the grant of a new lease, the creation of a new ground rent. From an investment perspective, which of course is where much of the anger is driven toward by the reform movement. From an investment perspective, Leasehold, following that particular item of legislation, then started to lose its muster, and as a vehicle, and certainly in terms of long-term returns, started to become far less attractive. Although, and of course, that did not stop existing stock and existing portfolios from changing hands. It just meant that simply ground rent as an investment perhaps wasn't as sexy as it had been historically for institutional and private investors. In my view, the ground rent, the first draft of ground rent legislation was essentially the beginning of the end for leasehold. And whilst we've not yet transitioned to an alternative system, largely because we don't have one yet, we are starting to see now the system, government, pressure groups really start to get ready for what we expect will be Commonhold, or a form of strata that we're used to seeing across Europe and in the United States. One of the first real casualties, if you like, of reform, though casualty is perhaps a generous description, would be leasehold houses. Much of the current discourse has arisen from the leasehold scandal, and the perception that many lessees were somehow induced into entering into these contracts and oblivious to what was contained within the leases and the contract. I'm not going to say abuse didn't happen, because I think it's very clear that it did. But equally, I think it's worth noting that lots of lessees who were caught up in the leasehold house scandal entered into these transactions with the benefit of legal advice. They would have known what the ground rent gearing may or may not have been within their occupational lease, and certainly would have had an appreciation that the cost of acquiring the freehold going forward would not perhaps have been as highlighted and advertised by the builder stroke developer. The issue really started to take hold when we were seeing really extreme examples in the press of ground rent accelerating at exponential rates measured against the capital growth in the property. I think my favourite from one of the broadsheets was, my ground rent will be 800,000 at the end of the term. And I remember sitting down and doing the math and thinking, well, in 1,000 years, how much is 800,000? But notwithstanding that, it is very, very clear that there have been some abuses. So I don't mean to discount those, but rather I think it's important to have some balance when we're looking at the wider interpretation of the Act, because I think, as you will see, it is a very lessee-favoured piece of legislation that is likely to cause some issues for both lessees and, of course, for our landlord clients, assuming you are, of course, a managing agent. So the 2024 Act deals with the thorny issue of leasehold houses quite definitively by stipulating that a person may not enter into an agreement to grant a long residential lease of a house on or after the day on which this section comes into force, unless it is a permitted lease. This means that, save for in exceptional cases, it will no longer be possible to sell a new home on a leasehold basis. Now, this signals a long-awaited ban on leasehold houses, which, and perversely, hadn't made its way into the first draft of the legislation. Looking at leasehold houses for just a moment and the issues that were attached to ground rent and the gearing, the aggressive increases, it's interesting that the legislation as we see today didn't and hasn't dealt with substantively the issue of maintenance and rent charges, which I think, on a weekly basis continue to cause some of my conveyancing clients issues, and certainly certainly issues for some of my managing agent and RMC clients also. So on one hand, we have this sweeping piece of legislation which is seen to right many historical wrongs and to give the reform movement that first win that, if you like, they're looking for. But actually, it's quite a superficial win in the sense that maintenance and estate rent charges continue, as do some of the issues that follow those charges. For instance, section 121, which we'll look at a little later. Moving away from the creation of leasehold houses, which has now been outlawed, subject to the various statutory instruments, and the point I made earlier about the legislation becoming fully effective. The 2020 or the 2024 Act also looked at the question of lease extensions and collective enfranchisement. Now, in the background to the leasehold house scandal, there had been, and is widely reported, an attack on the sector by a number of prominent politicians. The cost of extending lease, the costs and difficulties of enfranchising, marriage value, all really big ticket points for government to consider. So with the legislation, as we will see in a moment, the government have really taken a broad brush approach to it and have looked to address what they consider to be perceived injustices by making the process of extending a lease and also enfranchising much easier, and in some cases, and I stress in some cases, cheaper. Now, if we can look at lease extensions first, under the 1993 Leasehold Reform Housing and Urban Development Act, a lessee, as a precondition of making an application, was required to have owned the property for 2 years ahead of then being able to make a claim. Now, if you're a first-time buyer and you're purchasing a flat with 81 years and your solicitor wants you to extend the lease, then in that setting, and then under the 1993 Act, you had some difficulty. And really the only way to circumvent that would be to ask the vendor to serve notice of claim and to then assign the benefit of you. The new law, subject to inception, deals with that by removing the qualification criteria of two years. This would mean, as a first-time buyer, I can go into Chesterton's office today, find a flat that I want to buy, assuming I can afford to, and then extend the lease without necessarily having to wait that 2-year period, assuming, of course, all of the other criteria in the 93 Act have been met. And the likelihood is that they are likely to. In addition, and I'm sure many of you have experienced this, who act for landlords or RMCs, who retain the freehold. The 1993 Act is quite prescriptive in terms of the timescales that apply to certain steps that have to be engaged throughout the process. For instance, if you serve a notice of claim, the landlord typically had 2 months, or typically had 2 months in which to respond. That remains. Following the service of the landlord's counter notice, the tenant or the landlord have a further period in which to then make an application to the first-tier property tribunal to determine either the terms of the lease or the premium payable. Now, often what used to happen is, and certainly still does to a lesser extent, if a lessee had engaged a professional outside of the sector who perhaps didn't specialise as frequently as we all do, it wasn't unusual to see those claims running out of time, lawyers forgetting to make protective applications, lawyers withdrawing applications, not fully understanding the ramifications of that. And typically, in addition to a costs liability, one of the key provisions under the law as we are at the moment is that with a deemed withdrawal or with a withdrawal from the process, then the applicant is prohibited from making another claim for a period of 12 months. That, with the passing of the 2024 Act, has also now fallen away. This means that as a lessee, essentially you are able to make as many claims as is considered necessary, although one would have to question if you're making more than one claim at the end of a prescribed period of time, or following a deemed withdrawal, and perhaps and arguably you have the wrong solicitors looking after the matter for you. So to recap, the 2-year qualification period to extend a lease from a qualifying perspective has now fallen away, as too is the notion that a deemed withdrawal will result in you then having to wait a prescribed period of time before reapplying. And remember, as we are at the moment, having to wait 12 months for some lessees is fatal, more so where the lease sits at 81 or 80 years and runs the danger of then falling under 80, which of course is the magic number for marriage value purposes. Under the legislation, the process of extending the lease is largely speaking the same. When we look at costs a little bit later, that you will note, I think, with interest, that there are likely to be circumstances where for a landlord it is simply just not worth employing solicitors, but we will come to that shortly. In terms of those provisions under the new legislation, we can see that ground rent will remain at a peppercorn on completion, which is where we are now with the 93 Act, and that the lease, as opposed to being for a term of 90 years plus the unexpired term, will now be 990 years. From a valuation perspective, the differential here is actually very, 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 very small, and 990 compared to 189 or 215 from the commencement date of the lease is really seen, I think, as window dressing by some. What it does mean, however, at a very practical level, I think, if you're a lessee, is that it will now no longer be necessary to possibly go through the lease extension process again. Not that too much of that happened in the first instance. Then finally, and certainly with regard to lease extensions, a really important consideration for your landlord clients, as well as of course for lessees, is that there is no longer an obligation to meet the landlord's legal costs. So under the current regime, on service of a notice and completion of the lease extension, the landlord is able to recover their reasonable legal and valuation costs. That is now no longer the case, save for in a few exceptional circumstances. And this is that first step, if you like, toward making the process of extending a lease cheaper for a tenant. Those of us engaged in this type of work on a daily basis are used to hearing confiscation without compensation. And, if I'd had £1 for every time I've heard that in the last, 4 or 5 months, I'd be a very wealthy man. But essentially, if you're a landlord, you're being, with the new valuation methodology, which we'll look at shortly, you're being asked to give a lease extension where the financial return is likely to be far less than perhaps under the 93 Act. But in addition to, you're being asked to fund that loss, which to me, as a practitioner with a very mixed practice, that does feel a little unfair. But I think it falls in line with the government's aim of making the process cheaper and more affordable for lessees. So collective enfranchisement is the process by which a group of lessees get together and then decide they want to acquire the freehold of the building. Traditionally, and certainly over the last 5 or 6 years or so, the number of enfranchisement cases has dropped. Cost of living, COVID. There's a lot of property in London, and certainly outside of London, especially when we look at flats that are rented out. And I think for a multitude of other reasons, having to fund non-participant lessees, what we've seen is a slow reduction in enfranchisement numbers. From the perspective of government, their view, as with the Law Commission going into the process of reviewing the existing law, was that the position at the moment was too complicated. The bar was set too high, and it needed to be made much easier for lessees to acquire the freehold. Now, unlike a lease extension, there is no 2-year requirement for a lessee participating in a collective enfranchisement. Given that, government had to then take a look at how they could make the process easier for lessees. One of the first things that they have done, and there are 3 particularly important measures as part of an overview. In a collective enfranchisement application, typically you are looking for the non-residential footprint of the building to not exceed 25%. So, for instance, if you had a block of flats with a whole parade of shops, consideration to that commercial footprint was important. Government have since changed the limit, so that limit is now set at 50%. So that will mean, from a property management perspective, and hopefully from a legal perspective as well, because we still want to do some business, is that lessees are now going to have open and available to them a much broader spectrum of building, and buildings that traditionally, under the existing legislation, the 1993 Act, would not ordinarily have qualified for collective enfranchisement, are now possibly going to be available. This is likely to create a much more diverse management portfolio, I think, for those who specialise in managing or managing lessee-owned blocks. I'm not certain this is if I'm honest, the way forward. Large mixed blocks tend to require a lot more in terms of day-to-day management and hand-holding, and a very hands-on approach. Simply raising that limit, I'm not certain makes it easier. If anything, I think it's likely to make life much more complicated for tenants, in addition to the agents who they instruct to act on their behalf. In addition to the increase in the footprint of the non-residential areas, as with a lease extension claim, this notion of a deemed withdrawal also is falling away, which simply means that, again, we could be in a position where lessees are able to make multiple claims. I think most of us would argue that the requirement and the need to make multiple claims, or if you're running out of time or you're not making your protective applications as and when you need to. That lends itself, I think, probably to not the best legal advice, as opposed to being something inherently wrong with the law as it stands. However, from a managing agent's point of view, I think what we will see is that life, once the new law becomes fully embedded, is likely to become a lot more interesting and complicated, and that some of the larger blocks that we may see in our portfolios at the moment are going to be available to the lessees to enfranchise. I think looking at the law as we see it today, it had been my expectation that the 1967 Leasehold Reform Act and then the 1993 Leasehold Reform Housing and Urban Development Act would have been brought more closely aligned. And I think I was expecting something a little bit more substantive and less piecemeal than what we see now. The 1967 and the 1993 Acts, whilst providing lessees with significant rights to enfranchise and to extend leases, largely operate alongside each other. And the 67 Act, with each year that passes, becomes an item of legislation that we draw upon less and less. Having a piece of legislation that was more closely aligned with both acts and not dealing with service charge and maintenance charges may well have been a better position, I think, for lessees to have been in, if only because I think the business of statutory instrument and giving real effect to the substantive points of the bill would have been much easier. As it is, we've now got this mismatch of different parts of leasehold law that are going to need implementing at different times, which is then likely, I think, if you're a lessee, to lend itself to some frustration. Looking at the 67 and 93 Acts, there are some similarities. The qualifying period that exists in both pieces of legislation is falling away. And then we see this removal of significant penalty for deemed withdrawal. It's very clear that much of this legislation supports lessees and enfranchising and extending the leases. And I think that's to be welcomed. What I think is less clear is going to be the impact of the expanded enfranchisement rights for tenants and the financial implications to landlords who are shortly going to see, I think, their income attacked in terms of the return as an investment, and also then being in a position where they are having to fund these processes themselves. Short to medium term, I wouldn't expect to see a huge difference, but I think going into the next 5 or 10 years, we're going to see landlords and RMCs potentially under increasing financial pressure. And when we look at costs, I think it will become evident why it might have been different, or it might have been an idea to have dealt with lease extensions and collective as perhaps one item of legislation and banning leasehold houses, and then to have looked at service charge and everything else under a separate umbrella. However, I think the civil service and Mr. Gore certainly know better than I do. I think just in that vein, most commentators believe that we have missed an opportunity. The government, the commission have really, looked at the findings of the perceived abuses and have gone about this in a very broad brush way. And much the same as with the Building Safety Act, I think, as we've all seen, that lends itself to huge periods of inconsistent advice and narrative about the provisions and how they impact our clients. And also, it has resulted and will result, I think, in a much more delayed implementation of the law going forward, which doesn't help us as practitioners, you as managing agents, or indeed lessees as owners of the property. To recap, under both the 67 and 93 Act, we're now looking at a regime of 990 year lease extension houses and flats with a peppercorn rent. At the time of putting together these slides, which are sort of an overview we've taken from half a dozen other presentations, the valuation methodology has not yet been determined and set out definitively by government or the Secretary of State. We are still waiting on information concerning the deferment and capitalisation rates that are going to be set. Those rates are important when we're looking at determining the premium payable under a lease extension or a collective claim. And until those rates have been set, it's very difficult for us to comment on whether or not the process is going to be cheaper. Certainly for those lessees under 80 years, it very definitely is going to be cheaper because marriage value, which was a really nitty-gritty, sort of a real nitty-gritty part of that calculation, is falling away. And it is likely that that is going to lend itself to litigation from the landlords going forward. Of course, once the deferment and capitalisation rates have been set. Now, in addition to simplifying the process of extending the lease or buying the freehold, the Act also deals with the right on the part of a tenant to substitute the ground rent payable under an existing lease for a peppercorn. So as opposed to going through the process of extending a lease, if you have a qualifying lease as opposed to being a qualifying lessee, and by that we mean a lease with more than 150 years remaining on application, then it is going to be possible to make an application to vary the ground rent by way of a rent variation notice. Now, the process adopted largely follows that of claims under the 1993 and 67 Act, where you have a tenant serving a notice of claim and a landlord serving then a counter notice, with the First Tier Property Tribunal retaining oversight. It remains to be seen, I think, whether we will see an expansion of that opportunity and whether that will become very popular. There doesn't seem much point in buying out a ground rent if your lease is over 150 years and perhaps not taking the benefit of the extension as well, subject to the calculation and the valuation methodology, of course, which we're still waiting to be set out fully. In addition to lease extension and enfranchisement claims, right to manage has also been captured in the reform. The non-residential limit has been raised to 50%. Again, this is likely to result in a much wider and more complex management portfolio, and we are going to see larger, more complex mixed-use claims. And the First Tier Property Tribunal will also have a greater discretion to award non-litigation costs. And the discretion here, I think, is likely to be limited to where an RTM company have acted unreasonably. RTM, one of the few items of landlord and tenant legislation where there really isn't a defence outside of qualification or the claim not being populated correctly. The expansion of the right to up to that 50% non-residential, is that likely to make a significant difference? Possibly, as a cheaper alternative to collective enfranchisement. However, from your perspective as managing agents, I suspect it's likely to be a much more difficult undertaking going forward. When we looked at the beginning of the seminar at leasehold houses and the ban on leasehold houses, I think, like many commentators, like many practitioners going into the business of reviewing the reform, I was expecting to see a much more aggressive position taken with regard to Section 121 of the 1925 Law Property Act. Unfortunately, this hasn't happened, and at least to some degree, Section 121 remains unaffected, though it has had some of that potency limited by the changes. These changes are likely to be considered welcome and include estate managers now needing, or will need going forward, to subscribe to codes of practice, much the same as may be adopted by the RICS. Again, this drive to pass the blame, to make somebody else accountable for really, something that has been in place in the vast majority of instances at the point of creation of the legal estate. And then, more importantly, if you are a resident on one of these estates, is that reporting and accounting will be brought largely in line with service charge that one might pay under an occupational lease. So it is much more likely that tribunals who now have jurisdiction, or will have jurisdiction, to look at these matters are going to be looking at the costs and whether or not these are reasonable and have been reasonably incurred. So we're moving now from a situation where residents on estates impacted by these charges are going to have similar rights to tenants in blocks when they're looking at questioning service charge and whether or not they have been reasonably incurred. So this notion of being reasonably incurred, obviously coming forward into this arena, is going to make life easier. But then equally, from a practice perspective and from a property management perspective, it is likely that we will start to see more residents complaining about costs and wanting to know whether or not they've been reasonably incurred, or challenging whether or not the costs in the first instance are reasonable. So perversely, we have government taking with one hand and then almost giving back with the other. To me, it makes no sense, and there are different ways perhaps this could have been dealt with. In keeping with Section 20B of the 1985, that should be Land on Tenant Act, a similar provision is also created. And I think from a business perspective, it is very likely that as property managers, you can expect to see some pretty stringent requirements going forward as to the production of estate rent charge information and how you're able to charge and to recover your fees and providing that information. So we're moving from really an arena where there is lawlessness, would be the wrong word, because it's not that sort of arena, but certainly we're looking to enter into a much more prescriptive practice governed arena, where costs for production of information such as rent charge information are going to be limited as to the time to respond and to provide that information as part of a sales pack. Interestingly, there will also be a duty to consult similar to Section 20. Again, I think, like much of the legislation that we've seen within the 24 Act, it's all subject to further regulation, to statutory instrument, to further guidance from government. So at the moment, what we have is a framework. We have a wish list, if you like, of provisions which government have now enshrined in law, and really we're waiting by way of regulation and statutory instrument for those provisions to really start and take effect. At a very basic level, there's no huge rush to go out and change existing processes. However, I think it is very likely that following the election, we will start to see some of the perhaps easier to pass items start to drop, and whether that impacts, your practice will have to be determined, I think, on a block by block basis. But it is fair to say significant changes coming when we're looking at rent charge and service charge accounting, and the production of that information and the cost at which that information is to be made available. Returning very briefly to Section 121 of the 1925 Law of Property Act, it is, if I think if we're all honest, considered to be quite an antiquated piece of legislation, and certainly out of step with current thinking. It does cause issues when it comes to obtaining mortgage finance, and where Section 121 remains and deeds of variation aren't entered into, what we tend to see are sales that run perilously close to falling through because of the perceived risk of the property being subject to almost repossession in the same way that we see in a leasehold setting. The new legislation does tackle that to a small degree, not significantly. What it does provide is that when you are in a position where there are arrears, it will become necessary from the 24th of July of this year to issue not only a notice of demand of arrears, but also a copy of the deed or instrument which creates the rent charge or the charge. Quite what this does, I'm not certain, other than to provide a further period of notice for a tenant or a period of grace for a resident or a mortgage company to deal with the arrears, to me feels the obvious takeaway. However, I think many of us feel government could have and should have gone a little bit further when looking at Section 121 and the impact it can have for those trying to sell and to market their property. At the beginning of the seminar, we talked briefly about the adverse press that many of us have become accustomed to, and the reform movement have moved throughout this process from ground rent to forfeiture to marriage value to service charge, which is where they seem to be sitting. We seem to be sitting now, and in fact, just a look on LinkedIn this morning has shown there's a vast amount of negative press out there about property managers, property management sector, with many looking at regulation as a means to an end. Regulation, strictly speaking, I think is a little way off in the strictest sense. However, there are additional measures captured by the 2024 Act, which I think do translate to easy wins, but are going to need significant lead-in times for property management businesses and for those engaged in looking after stock on behalf of RMC or landlord clients. So one of the many issues that seems to almost be talked about all of the time is the delay in obtaining information, whether it's on a state service charge or service charge in the production of LPA1. Government have looked at this, continue to look at this, and have looked at this historically. Going forward, there is nothing set in stone as of yet. It is proposed that there will be a prescribed time in which to respond to requests for this information, and that costs will be fixed for the production of the same. There isn't yet a definitive position on time and cost. We're still waiting, as with much of the Act, if not all of it, for statutory instrument and further regulation. It is likely, I think, when this particular area of reform takes hold, that we will see a significant impact on day-to-day operations, which is why I think as managing agents, it's important to look at the Act now as a framework for what your business is likely to look like in a year's time. The more you're able to do now, obviously, the better. The really easy wins. So the term landlord is now much more encompassing and will capture right to manage and resident management companies. I'm not certain many of us thought about that too much. And the rights that lessees have, subject to Section 22 of the 1985 Act, to inspect documents relating to service charge. There's going to be an expansion of those rights. This feels, of course, far less restrictive, but it does become a much more punitive regime in a sense that lessees, who are likely to always want to question service charge and the levels and what their managing agents are doing or not doing, have much more now in terms of power to exert over the agents to produce information and to inspect. And when we see the law become fully effective, then I think it's very likely that we will see more lessees asking their managing agents to inspect and to look at the costs a lot more closely, more regularly. The downside, of course, to that is that it's going to have an impact on management cost and indirectly then service charge. Section 53(2)(b) creates a new definition of service charge, and that can be, or that is, an amount payable by a tenant in which is payable directly or indirectly for the purposes of meeting and contributing toward relevant costs and variable service charge as a service charge of the whole or part, which varies or may not vary according to relevant cost. So we've now got a much more embracing definition of service charge, whereas in the past, fixed service charges often sat outside of some of the statutory regime. And then relevant costs are costs or estimated costs incurred by or on behalf of a landlord in connection with services, repairs, maintenance, improvements, or insurance. In addition to having some lovely new language to play with, there will be a new form of service charge demand. Again, we don't know what the form of that will be. We don't know when that is likely to become fully effective, which is why I go back to my earlier remark about having some significant lead-in times. Businesses are going to need time to get ready for this. And I think the 2025, 26, possibly even 26 to 28 timeframe does feel realistic. Although there is the danger, I suppose, that the longer this goes on, we transition toward a 2002 Act scenario that largely has failed to make a significant impact on the statute books. Section 22(b) notices are to be amended to reflect that future notices must now contain prescribed information, details of the amount the lessee is required to contribute, and the date upon which the items will be collected as a service charge. It is likely that once the new service charge regime is fully understood with the prescribed forms, etc., that, and with the expansion of rights that we're now going to see for tenants to inspect, compliance and ensuring that all of our documentation is as it needs to be is going to be ever more important. And I think if we're all honest, we've all seen demands that have failed to tick the statutory box from time to time. In addition to the provision of a prescribed form of service charge, demand. Landlords will also be required to provide a statement of account in writing, which will be accompanied by a report prepared by an accountant. A reasonable fee is going to be able to be recovered for the production of this report, which will detail and provide more than a balance sheet to the service charge statement and accounts that are produced by you as property managers. Almost a narrative, if you like, to the service charge demand and information that is already provided. The law, as it's drafted, does allow for further reporting, as may be at the discretion of a prescribed authority, trading standards, possibly even local authorities. We don't know is the short answer. But in addition to a new regime in terms of form of demand and some lovely new wording to play with, despite not needing too much attention, we're moving very, very, very quickly, I think, into that area, or that arena rather, of transparency that government have been pushing in concert with the reform movement for some time. Service charge account and demand is not likely going forward to be sufficient. You're going to have your service charge account, your breakdown, and of course your statement detailing the cost and expenditure, and then signed off by a suitably appointed accountant, all of which of course incurs a further reasonable fee at a time when really the aim of the Act is to make life easier and cheaper for lessees. In addition to the prescribed report, landlords will be required to publish administration charge schedules. The schedule will need to capture the amount and how this is determined, where this is not, of course, known in advance. The schedule will need to be provided to lessees, and where these requirements are not met, the position will be that potentially a charge is then not payable. In addition, lessees may also bring a claim against the landlord for failure to publish, with compensation not exceeding £1,000. I'm not entirely certain why it was necessary to go that extra step. Lessees are being afforded greater transparency. Lessees, I think, are being given an opportunity, a wider opportunity to inspect, and landlords and their agents are being asked to undertake more work, it feels, for, at the moment, either the same or less. To then bring in a further punitive measure feels a little unnecessary in my view, but bigger and greater minds have determined that. I think it's fair to say that the new legislation takes a far softer tone as to the liability on the part of a landlord, on the part of a lessee, to meet their landlord's costs when we look at lease extension, RTM, and collective enfranchisement, for instance, where the obligation to meet costs has fallen away. In addition, however, there are far more sweeping and potentially damaging provisions that we need to consider. Principally, that a landlord's litigation costs are not to be regarded as a relevant cost to be taken into account in determining the amount of variable service charge, whether or not the charge is payable. Now, while secondary legislation is likely here, and we will see some exemptions, hopefully, it's too early to forecast what they might be, but the landlord's ability to recover litigation costs through the service charge is, on the removal of that, is significant. And I think that is likely to result in blocks where, on breach, it becomes much more difficult to take definitive action, more so where there isn't a professional landlord in situ who is prepared to carry the risk. And the position for RMCs and blocks where lessees are collectively enfranchised is likely, subject to the individual leases, to become much more difficult. I'm not certain there's much sense in that particular provision serve as a soundbite. The legislation is drafted in a way that allows, I think, some exemptions. I have been a party to conversations where it has been suggested those exemptions will extend to RMC and companies who comprise of lessees. Whether that is the case remains to be seen. However, this particular provision within the legislation, I think, is likely to result in a far more difficult landscape for landlords to now litigate on breach and for landlords to litigate more generally. In addition to the provision dealing with the litigation costs, there will also now be an implied term within a lease that provides that if there are relevant proceedings concerning a lease and a relevant court or tribunal so orders on application by the tenant, the landlord pay an amount in respect of all or any of the tenant's litigation costs in connection with the proceedings. The landlord must pay the tenant the amount ordered. So all leases will carry an implied term that any proceedings commenced and born of the act, of the lease rather, the tenant on application can ask that their costs are met by the landlord. How that will be determined by a court or a tribunal is, I think, beyond the scope of what we can talk about today, but it has the potential to move yet if further, I'll rephrase, it is yet another move away from the notion that there is any need for a professional landlord, in the sense that with ground rent potentially going to be capped, with premiums for extending leases and enfranchising likely to be much cheaper, with no costs payable on those applications, and in addition to not be able to recover litigation costs, this final provision seems to be in my view, the cherry on the cake, and we have now gone almost 360 in putting the lessee now, I think, firmly in charge of the landlord and tenant relationship, whereas I think most practitioners would accept that they need to exist on a level playing field. This particular bill, this particular piece of legislation, in my view, doesn't deliver that. It is likely to make life more complicated for you guys as managing agents, and I think also it is likely to see an increase in costs and blocks where breach is rampant. However, let's see how the Act plays out, and at the various points of inception, whether the law is amended to capture some of the and many publicised unintended consequences. As a final point, the new legislation effectively brings an end to insurance commission, although that has been the case for a little while. The legislation does allow a permitted insurance payment to be recoverable. However, the nature of this payment and the manner in which it might be collected has yet to be set out. The Act suggests that this is something likely to be the Act is suggesting that this is something likely to be determined quite harshly, meaning quite a narrow environment to navigate. Costs not considered permitted might even then conceivably result in a demand having not been made at all. This again is part of that move toward greater transparency around insurance cost overall. And I think that brings an end to our presentation. I appreciate that there is perhaps a lot we haven't covered, and in truth we did struggle to put together something that was less than 2 3/4 hours, and believe me, talking for 2 3/4 hours isn't something that I would necessarily volunteer to, and certainly not looking down a singular lens in a small room in my office. But I think we've seen from the legislation that the balance that lessees have been seeking for such a long period of time has been delivered in a really robust manner. Marriage value, costs, litigation, enfranchisement, lease extension, all gone, all gone. We're moving toward regulation to prescribed forms of demand in terms of service charge, and I think that has to come with some cost attached to it. And unfortunately, that cost is only going to be borne by the lessee. So on that note, thank you all for attending.
Thank you, Darren. That was brilliant. I think you got through it great in just over an hour. Amazing.
Yeah.
We do have a few questions there. We haven't really got much time to go through them. So what I will do is I'm going to pass them on to Darren, and then he will try and get back to you individually, as long as you've left your contact details there. If anyone missed the webinar or couldn't sort of stay for the last 10 minutes, it has been recorded, so it will also be available to watch back on our YouTube channel later today. Otherwise, thank you very much, Darren, for your time. Thank you everyone for joining us. We do have another couple of webinars coming up over the next few weeks, so please do have a look on the News on the Block website, where you'll be able to register. And I look forward to seeing you on the next one. Thanks, Darren. Enjoy the rest of your day.
Thank you very much.
Thank you. Bye.